It is easy to assume that sitting down with a lawyer to draft a will is a task reserved for billionaires, or something you only need to think about in your twilight years. But estate planning actually has very little to do with how much money is in your bank account. It is a proactive use of the civil law system to maintain control over your assets, provide clarity for your loved ones, and legally protect your family. Many people avoid the paperwork because they believe their family already knows what they would have wanted. In the United States, the civil justice system relies strictly on codified written statutes to resolve private disputes. Without a document that meets specific statutory requirements, the court has no legal mechanism to recognize a handshake agreement, a whispered promise, or a text message. If you pass away without legally documenting your wishes, your personal intentions are effectively erased from the legal record. You leave behind a jurisdictional vacuum, and the state will step in to fill it. The legal term for this vacuum is intestacy. When a person dies intestate, meaning without a valid will, state civil statutes automatically trigger to resolve the distribution of property. A specialized state probate court takes over the process, effectively stripping your family of the ability to resolve your estate privately. Instead of your personal wishes guiding the outcome, state law applies a rigid formula to determine the exact hierarchy of who receives your property. And if you have minor children, the stakes are much higher than a bank account. A judge, who has never met you or your kids, will dictate who is appointed as their legal guardian based on the state's specific criteria. By defaulting to intestacy, you surrender the most intimate, consequential decisions about your children and your legacy to the default statutes of a state court. Even for those who do write a will, there is a common assumption that this single document controls absolutely everything you own. In truth, a will is just one piece of the civil law puzzle, and it has strict jurisdictional limits over what it can actually distribute. Certain accounts are classified as non-probate assets. These include life insurance policies, retirement accounts, and payable on death bank accounts, which operate as independent legal contracts. Because they are independent contracts, they bypass the probate court entirely and operate on their own parallel legal track. If your will states that a specific asset goes to your current spouse, but a beneficiary form from 10 years ago still lists your ex-spouse, the beneficiary designation legally wins. A static will is vulnerable. Unchecked beneficiary contracts can completely bypass the probate system and override your final written wishes. For high net worth estates, planning requires a shield against federal taxation. The expiration of the Tax Cuts and Jobs Act and the 2026 OBBA altered this. This chart shows the rising threshold for federal estate tax exemptions. The OBBA permanently increased the basic exclusion amount, shielding wealth all the way up to a massive $15 million threshold. However, federal taxes are only part of the equation. Because most estate law is state-specific, simply moving your primary residence across state borders alters how local courts will interpret your documents. Other major life events, like a marriage, a divorce, or the birth of a child, can also immediately render your existing estate documents legally obsolete under those state laws. Your legacy is constantly under threat at the volatile intersection of shifting state laws, personal life changes, and evolving federal tax codes. To maintain control, you have to treat your estate plan as a living strategy. Anytime you experience a major life event or there is a significant legislative change, you must update your documents immediately. A fully protected estate relies on a holistic legal shield that coordinates several distinct instruments to protect different facets of your life. This diagram shows what a complete estate plan actually looks like. It is a central hub connecting 4 active components: your will, a power of attorney, healthcare directives, and updated beneficiary forms, all working in unison. These synchronized civil tools are the only way to proactively keep state interference out of your family's private business. Establishing these protections is an act of preventative legal care. It uses your private civil rights to ensure your family's future is dictated by your own choices, not by a default state statute. But what happens when your private property rights are challenged while you are still alive? Next time, we'll explore how to protect your real estate when squatters and trespassers try to claim it as their own.